Ladies and gentlemen, if I can have your attention, we're going to go ahead and get started. Chairman Smith is not going to be with us this week. Unfortunately, he has been diagnosed with flu, so I'm sure that we all, join in prayer with him that he will be returning post-haste to the chairmanship. To that end, I would like to recognize the Secretary of the Committee, Chairman Jaspers, to lead us in prayer before we get started.
Thank you all. Before we do start with our prayer, I know we all have heavy hearts this morning. The loss of a trooper in the line of duty, and I think hope all of us today keep two families in mind. You know, the family of troopers and the family of our fallen trooper. I mean, it's a very sad day for them, and so as we see them guarding us today, just take time to recognize them and their loss of their groups. We'll bow together. Heavenly Father, please look over this trooper family and this family of our fallen trooper. Put your arms around them and let us put our arms around them and comfort them in this time of loss. And, Heavenly Father, we know we've got a lot of our members out sick with COVID or the flu, and please keep them wealthy, get that chicken soup to them, and so that they can be back with us as soon as possible. Lord, as always, give us wisdom, kindness, encouragement for one another in the work we do down here. This is in your name. Amen.
Thank you. Representative, we'll recognize you first to present your bill.
Thank you, Madam Chair. Good morning. I bring to y'all this morning House Bill 501, and we do have a substitute from the committee hearing. And so the LC number I will be working off as LC 520408S. The first part of this bill is I really have to credit with Representative Schofield. This is just going to prohibit employers from discriminating against employees based solely on their age if they are 40 years of age or older. Section 2 will allow a minor 14 years or older to work without an employment certificate outside of school hours. There are numerous safeguards to protect minors both in this bill as well as in the Georgia Code and the Federal Code. For example, on line 53, the employer must have either an accident and sickness insurance plan or a workers' compensation insurance plan in place. Second, the youth's work must be limited to the customers of the employer under lines 57 through 61. Youth work permits are not required under federal law per the Federal Labor Standards Act. Both Georgia law under OCGA 39-220 as well as federal law under 29 U.S.C. 216 still hold bad actors accountable for violation of child labor laws. Federal law, moreover, still requires businesses to keep records of hours worked, wages paid, and the employee's age if the employee is under 19 under CFR Part 516. Georgia law still prohibits teenagers from working during school hours. Georgia law OCGA 39-2, and 7 limit the number of hours and times that 14 and 15-year-olds may work, but Georgia follows federal law with respect to 16 and 17-year-olds that does not restrict times or hours worked. Georgia law still prohibits 14 or 15-year-olds from working in dangerous occupations, including any work in a mill, factory, laundry, manufacturing establishment, workshop, or any other occupation deemed dangerous by the Labor Commissioner. Federal law prohibits any teenager under 18 from working in hazardous occupations in 29 CFR 570. These professions include roofing, mining, forestry, working with balers, compactors, meat slicers, high-powered dough mixers, or bread slicers. Last but not least, the Department of Labor has approved this bill, and the Georgia Chamber of Commerce supports this bill as well and is preparing a letter of support to go on our desks. So I'd appreciate your favorable consideration.
Thank you for that presentation. Any questions? Representative Park.
Thank you, Madam Chair. Representative Silcox, is it not true that on lines 68 to 73, this bill would prohibit state and local governments from issuing an employment certificate to verify the age of a minor for employment purposes that may weaken child labor protections and possibly endanger children's lives?
Mr. Whip, I appreciate your comments, but I did give an extensive list of other protections they have outside of that.
Will you yield for one more? Is it not true that in the state of Georgia, the minimum working age, if the Fair Labor Standards Act does not apply, is 12 years old? And so, for example, if we're not issuing employment certificates to verify the age of a minor, 10, 11, 12, 13, that some of those children in where the FLSA does not apply could potentially be endangered?
This would only be 14, down to 14.
Okay, thank you. Speaker Pro Tem Jones.
Thank you. Representative, could you explain the effect of Section 1? The effect.
Oh, the effect is to prohibit age discrimination.
Specifically, would prohibit against one category of voters, right?
Correct.
Above age
Mhm.
70.
Correct.
Currently, one can exercise age discrimination if you are 71 or older.
Correct.
Representative Hughley.
Thank you, Madam Chairman. To the author of the bill, I thought I heard you to say that children will still be prohibited from working in dangerous
Correct.
occupations.
Yeah, those listed in the law as well as any other deemed dangerous by the Labor Commissioner.
So lawn maintenance is not dangerous?
If it was deemed by the Labor Commissioner to be so, then it could be considered dangerous, but it's not currently.
Okay.
All right, thank you. No more questions. Thank you, Representative.
Thank you so much.
Representative Alexander.
Thank you, Madam Chair and committee members. I bring to your attention HB 884. It's legislation to add a fourth judge of the Superior Courts to Douglas Judicial Circuit. The reason for this request is because our chief judge, who's retiring at the end of the year, wanted to make sure that we tried to get this bill this year since he's retiring. Other reasons, Douglas County ranks number 3 for new judgeship. Currently, 3 judges are doing the workload of 4.5 judges. For the past several years, Douglas County have not added a Superior Court judge since 1998. Also, the governor has included this 4th judge in the budget. I want to bring to your attention specifically, all the language in this bill is similar to previous language passed as it relates to adding a judge. But I want to bring to your attention Section 3. And the reason for that is because the language, we had to continually go back and try to change this language. Originally, Ledge Council had it for 6 months. But it mirrors other judgeships in other counties, so this legislation actually staggers the term and allows for the election in 2026 after the appointment from the governor. So I ask for your favor or consideration for this legislation.
Thank you, Representative. Any questions? Seeing none, thank you.
Thank you, Madam Chair.
Chairman LaHood.
Thank you, Madam Chairman. I bring to you this morning House Bill 976 that passed the Governmental Affairs Committee last week. And what this bill does is it's an election security and voter confidence bill. And what it does is it adds a visible watermark to the paper ballots, both absentee and BMD ballots. And this is a security feature that gives voters confidence and gives poll workers, a visible watermark to know it's an official ballot that they're processing.
Thank you. Representative Park.
Thank you, Madam Chair. To the representative, how much will this cost the state, and has an appropriation been requested so that these watermarks could be utilized for this election cycle?
Okay, so it's estimated by the Secretary of State's office this will be a one-time cost of approximately $110,000. So I would call that a low-cost, high-value spend.
And is that in the budget or the governor's proposal?
I'm working with appropriations on that, yes.
Thank you.
Okay, thank you. Representative Hughley.
My question is.
Okay. Representative Williams.
Thank you, Madam Chair. To the gentleman, just a quick question, and most of it we can talk offline. I wanted an explanation of the watermark difference, because is it not true I'm probably the only one in here that had a paper ballot election blatantly stolen?
I'm sorry, could you repeat your question?
I'd like to get some explanation of what the watermark does. I know what the intent is, but what the watermark does, because I had an election stolen by paper ballots, and I've never thought it was a safe way, but I certainly know things probably have improved.
Okay, so this bill would not change the way we're processing elections. It just simply puts a visible security feature on the ballot, and this could be in addition to the existing I'd call it an invisible security feature that's there now, the ceramic coating that requires a wand to verify that it's a ballot, it's a official ballot. This will just add a visible security feature so that you can see it with your eyes.
Okay, thank you. Chair Lady Smith.
Thank you. Thank you for bringing this piece of legislation. Is it not true that several years ago my husband and I actually printed ballots for the state of Georgia in our printing business? Is it further not true that I agree with the statements you worry about bond paper that has no watermarks? And is it further not true that watermark is a distinct impression on paper that is proprietary to the one who has the watermark? Therefore, it is a very good safeguard for our ballots. Thank you.
Yep, I believe you know what you speak.
Thank you, Madam Chair. Seeing no more questions, thank you.
All right, appreciate your consideration.
Representative Yurda.
Thank you, Madam Chair. Committee, I bring before you House Bill 906. It's LC 48106-9S. This would provide for a third judge of the Superior Courts of Tifton Judicial Circuit. 4 counties make up the circuit: Irwin, Tift, Turner, and Worth County. The judge workload is 1.41, the highest workload value of any requesting circuit. The Tifton Judicial Circuit last received its last judgeship, and 43 years ago in 1980, the year I graduated the University of Georgia. In that time, the circuit's grown 25% in population. In 2023, Superior Court judges spent an average of 16 working days a month in court, and they are scheduled to do about the same this year in 24. Currently, there are 31 murders pending in the circuit, 94 serious felony pending, and there are 2,951 open felony cases. So they have a tremendous workload, and actually the Judicial Council of Georgia met to consider, ranking, and the Tifton Judicial Circuit ranked #1 in need in that evaluation. Just ask for your favorable consideration.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
Representative Seabaugh.
Thank you, Madam Chair. Committee, today I bring to you House Bill 451. If passed, House Bill 451 will establish a requirement that all public entities in Georgia offer a benefit program for first responders diagnosed with PTSD that is a result of exposure to in-line-of-duty traumatic events. The intent of House Bill 51 is to create a once-per-lifetime financial safety net for first responders to assist with uninsured costs associated with treatment and recovery. A first responder may access the benefits quickly and confidentially without worry over stigma or job loss. House Bill 451 will save first responders' lives and support public safety by helping them seek early diagnosis and treatment of PTSD and continue their work as a first responder. And with that, I'm happy to take any questions.
Thank you. Any questions? Speaker Pro Tem Jones.
Thank you, Madam Chair. I had a question, Representative. So this would be sort of akin to those who might buy cancer insurance or other specific insurance. This would be a specific category. Is this for mental health counseling generally?
That's correct. It'll be a supplemental benefit similar to the cancer benefit that we passed for firefighters. But it'll be a supplemental benefit to help cover those uncovered costs that would be covered in their medical benefit.
Is it true or not true that this would be covered under the legislation we passed earlier that requires mental health parity?
So this would be a supplement to that benefit. So while insurance companies will provide a medical benefit, the first responder may still have to come out of pocket 20%, 30%.
Mm-hmm.
They're also, because of a shortage of psychologists and other mental health professionals, they may have to drive long distances. So it would help cover fuel cost, child care cost, whatever those extra non-covered benefits are through their medical benefit.
Thank you.
Okay. All right. Thank you, Speaker Pro Tem. Chair Williamson.
Thank you, Madam Chair. Representative, help me understand this a little bit better. The Pro Tem mentioned supplemental insurance products, such as oftentimes workplace marketing products include supplemental life insurance, accidental sickness benefits at a specified dollar amount. And we have one major player in that industry in Georgia, as well as several other competitors. Have you talked to any of these providers? Is this product in fact available by any of these supplemental insurance product providers?
Yes, currently, and they've been working on this language and legislation for about 4 years now, and they're a cadre of professionals that have been working on this. They tried to get a bill through a couple of years ago as a workers' comp bill, which was extremely expensive. This is a very affordable offer. It's about $155 per first responder. It's about a $1.6 million appropriation for the state, which has been submitted to appropriations last year and again this year. But currently, there's one provider that offers both of the benefits that this supplement would offer. That's not to say that other providers would step in after the passage of this bill.
Thank you. That answers
Yes,
my question.
Okay. Thank you. Speaker Pro Tem Jones.
So I had a follow-up question. So are you suggesting the state would pay this for the entire state, or that local governments would pay for their own employees?
Yeah, the state would pay for the state first responders, correctional officers, GSP, Capitol Police, FBI, and the local governments, ACCG and GMA, both on board with this, will pay for their individual first responders.
And then I had a follow-up. I noted there's also a one-time payout if you're diagnosed with PTSD. Is that correct, of $10,000?
That's correct. So upon diagnosis, they'll receive a $10,000 cash benefit for the first 90 days of their treatment. If after 90 days they cannot return to work, they will, a 36-month long-term benefit would kick in to cover them until we can get them back to work. Statistics show that usually within 2 years they return to work, and this is a lifetime benefit, so if you only use 2 years, you still have 1 year left if another event occurred.
Thank you.
All right. Thank you. Minority Leader Beverly.
Thank you, Madam Chair. Speaker Pro Tem took the question right out of my mouth. So thank you for asking the question.
Okay, thank you. Representative Park.
Thank you, Madam Chair. To the author of the bill, is it not true that this bill is otherwise narrowly tailored, as it's just looking at first responders and ensuring or perhaps codifying for purposes of uniformity that PTSD would otherwise be covered under their insurance policies?
That's true. PTSD would be covered under their medical benefit, thanks to House Bill 1013, but this is a supplement to what that insurance benefit does not cover.
Thank you.
Okay, thank you. Do you have another bill? Representative,
Yes,
do you have another bill?
I do.
Okay.
We ready?
Yep.
Thank you again. This will be House Bill 883. This bill is at the request of several public health boards throughout the state. This bill will amend Code Section 501401 relating to open meetings, public open meetings, so as to authorize county boards of health and community service boards to conduct meetings via teleconference. Happy to answer any questions.
Okay. Secretary Jaspers.
Thank you, Madam Chairman. Representative, you look at this, do you think, so you're saying that it's wise policy for a board to, if the governing body so chooses to never meet in person?
No, Mr. Chairman, I'm not saying that at all. What this bill will do is, we found during COVID that the board members' participation and the public participation was enhanced in some of our more rural South County communities because of the drive distance. Some public health directors are having to drive, 2 hours to get to a board meeting. And the people that are on these boards are busy professionals. We have doctors, we have school superintendents, very busy schedules, and often they're not able to participate. But with a teleconference option, they could participate for an hour in these board meetings, which I think would help. This does not require all boards to meet via teleconference, but it does give them the opportunity to do so if needed.
Madam Chair, if I may, it seems to me, just personally, that it would be behoove for better working to at least have them meet once a year in person, because some will take advantage of this and not ever meet in person.
I would agree, and that is not the intent of the legislation, is to never meet in person. It really would be a supplement. And these meetings will have to follow the open meeting laws as they are. So they will have to advertise if these meetings are going to be in person or teleconference, so that the public would know how to access these meetings.
Okay, all right, thank you. Representative Williams.
Thank you, Madam Chair. I just wanted to kind of piggyback on Representative Jaspers. My question is, was it ever considered that there be an excuse mode, that if you can't make it or for some valid reason, then you can go online? But do you see this possibly causing a very empty room? Just, I'm just wondering if you considered that at all, that's not just everybody can stay home, but just have a reason.
Yes, sir. This bill has been debated for many, many years before I got to the House. I think during the pandemic, they saw the benefit in being able to offer that option, and they asked that I draft a bill to help codify that.
Follow-up, I by no means am saying I oppose the bill. It's just that being from the old school, if you accept an appointment, you accept the responsibilities of the appointment. That's just my thought.
100% agree.
All right, thank you, Representative. No more questions, thank you.
Thank you very much.
Representative Anderson?
Thank you, Madam Chair. This morning, committee, I bring before you House Bill 813, working from LC 472709S. It's 5 down from the top on the blue sheet. House Bill 813 codifies the cityhood process. 2 years ago, when I chaired our cityhood subcommittee of governmental affairs, I learned, unbeknownst to me at the time, that the process, the 2-year process that's been practiced, exercised, and followed for decades here in this chamber does not exist in state law. It only exists in House Governmental Affairs Committee rules. That's a scary proposition, regardless of which side of the aisle you're on, regardless of which side of the opinion you're on regarding these matters. We're creating cities. That's a municipal corporation. This is an organization of individuals who get appointed or elected who have taxing authority over the people that participate in that city. This shouldn't be something that is subject to the whim of a committee vote. It should be something that is extremely intentional. This bill requires the creation of a cityhood initiative committee. It defines that committee that they do have to report through the state ethics board. It also requires a petition with defined limits on the number of petitioners to proceed and go forward. It requires that the legislation creating the city be brought forth by legislators who have vested interests. They must represent all or portion of the area that's being considered for the city creation. It also requires the interim studies, a financial impact study and a service delivery strategy summary in the interim between. It's still a 2-year process like we've always used, but in that interim it does require those studies. And then finally, it requires a referendum. And that referendum, again, should be an intentional and conscious vote by the people who are going to be affected. So this bill requires a supermajority of 55% minimum for the cityhood referendum to pass. Madam Chair, that's the bill, and I'll take any questions.
Okay. Speaker Pro Tem Jones.
Thank you, and thank you, Representative. What other things are in state law other than constitutional amendments that require above a 50% plus one vote?
That's a question I don't know the exact answer to. I'll be glad to look into that. Again, the intent there, and this was my prerogative in writing the bill, is to make sure this was an intentional act. It doesn't need to be something that can be controlled by special interest, especially when you have when you're talking about forming a city, you're talking about a small populace of relatively of voters. And so, typically voter motivation becomes an issue in off-cycle elections or limited elections. So I wanted to make sure this was intentional.
Well, may I ask, Representative, is it true that we allow 50% plus one vote to elect a governor?
Correct.
And further, is it true that when we worked very hard for 20 years to allow Sandy Springs to vote, it was 100,000 people, so it's not always a small number. In fact, most of the new cities that have been created are larger in size than 90% of the cities that pre-existed them.
That is correct, Madam. The concern I have, however, is not only do we need to make sure this applies for those types of scenarios. If we look at it from a county basis, any law that we pass as a state law needs to not only apply in Fulton County, it also needs to apply in Taliaferro County.
Certainly.
Thank you.
Okay. Thank you. Chairman Smith.
Good morning. Thank you for bringing this initiative to the General Assembly. I have a question that goes in the opposite direction. Several years ago, some of my members will remember this, we passed a bill, it became a law, where we can remove the charter of a city. And so that has to meet certain specific conditions for the local delegation to be able to do that. Does this legislation in any way change that process?
Thank you for the question, and the answer is no, it does not. We looked, and I wanted to make sure that there was not a conflict with that. If anything, that becomes the enforcing manner after the new city creation goes into play. So this actually fits right in prior to in sequence prior to that particular provision of state law coming into play.
Thank you very much. One further question.
Yes.
Is it not true that although it seems strange to remove a charter from a city, our cities are created by statute, and our counties are created by the Constitution. And so that is why we had to form this particular process. Thank you.
That would be true, and just to kind of further, one thing that I failed to mention earlier that is in this bill is the prohibition of what we commonly refer to as city lights or a limited service city that has been understood and follows into the charter dissolution component that's already in code.
Okay. Thank you. Leader Beverly.
Thank you, Madam Chair. I want to just follow up real quick on the 55% of the voters. What voters are you specifically talking about? Are they registered voters? Are they voters who are going to be impacted? Who are the voters specifically that you're talking about that have to be a part of this referendum?
Thank you for the question, and that's good. First of all, the people who would vote on the cityhood initiative legislation would be those that would be impacted or those that would be part of that geographical area. The 55% would be 55% of the voters who participate in voting in that particular cycle.
Thank you. Chairman Newton.
Thank you, Madam Chair. Sir, I guess I'm going to go one more time at the 55%. That does mean that 46% of the voters could overrule the majority of voters that wanted this to happen, which normally requires we do that with constitutional things here in this body, but even at the constitutional amendments, just 50 plus 1. Do we really want a minority of voters to overrule a majority of voters in this case? And the second part of the question is, you mentioned it's currently not based on Georgia law, but on committee rules and regulations. Is this a significant change from the way it is now?
Thank you for that question. First of all, again, the intent that I had in drafting this legislation was that the process be intentional and it be for the consensus and good of that group of individuals. That's why I wanted more than a 50% plus 1 built into this. By the same token, if you look at it on the other way, current committee rules don't even require a majority vote. The establishment of a city in current committee rules depends on whatever the legislation, local bill that is being dropped to create that city specifies. It could be any percentage. There's nothing specified in current committee rules at all.
Okay. All right. Chairman Blackman.
Thank you, Madam Chair. Representative Anderson, you mentioned intent. I mean, aren't you really trying to enhance the success of these applications as they move forward with what you've put together here in order to reach certain benchmarks and standardize the process?
Thank you for that question, and absolutely, yes, that is the purpose of this. Again, when I chaired the subcommittee 2 years ago, if you recall, we had at that time and during that session 5 cityhood bills presented to the House. 4 of those, of course, achieved passage in the House. Of those 4, only 1 passed the referendum process. That's a lot of work that went into efforts that possibly could have been clarified, could have been defined better up front had we had statutory guidelines that would allow that to take place, a more intentional effort.
Okay, thank you. Representative Drenner.
Thank you, Madam Chair. Just a quick question regarding the fiscal impact study. How long, is there a duration that the fiscal impact study is still applicable?
Okay, well, the fiscal impact study is required in this to be performed between the 2 years between the introduction of the bill and then when the bill is eligible to be acted on by the legislature. So that study, it's currently done. Okay, these fiscal impact studies are currently done by secondary educational institutions. However, this makes no change to that process. We define the components that need to be looked at, but we don't really define the term or basically the content of that study beyond what is already done.
Okay. Question, Madam Chair.
Okay.
what I'm really getting at is if by chance the measure does not pass during that 2-year time period and somebody reintroduces the bill, or is the fiscal impact study still relevant, or do they have to get another fiscal impact study?
The way this bill is currently written, there would have to be a new study conducted. Circumstances could have changed, situations may have changed. We don't really have provision to reintroduce a study in the bill the way it's currently written.
Okay. Thank you. Chairman Cooper?
Well, I happen to live in one of those areas where they had the 4 cities, my county, and I apologize for coming in late. I have a sick animal. I don't understand about the 55 benchmark. I mean, why is it not good enough 50% plus 1? I don't agree that we should be changing that. I mean, and why was the thinking behind that? And what else have you changed that makes it different? I think people have a right, if they come and bring forward a possible cityhood and they do all the things like they did for those 3 that failed, I think they have a right to go forward. Are you trying to stop that from so many coming forward and asking to be cities?
Nope. Thank you for the question, Madam Chair. And the answer is no, we're not trying to stop anything. What we are trying to do is to make sure that, particularly in situations to where you're dealing with a smaller municipal corporation or a smaller city, that special interest groups or individuals who have something to gain from the process aren't, there's checks and balances. The 55%, as I said, was a number that I put in here, again, intending it to be an intentional process to create a taxing authority that can impose taxes on even the 40-something% who oppose it. As far as changes, we're changing items and enhancing items that are currently in committee rules. We're not changing anything that is in current state code because nothing exists. This is creating a process in state code that is now only a skeleton of a process in committee rules. Committee rules doesn't require a referendum. We can actually pass bills in this House without having a public referendum to create a city. That is not a violation of that rule. It's not a violation of state law. So we're defining that, and yes, the 55% is a little, it's higher than we normally require on things. However, again, I get back to the point, my personal opinion and my feelings on behalf of the people I represent in the state, I feel like when you create a legally binding taxing authority, it should be an intentional act.
Second question.
Okay. Very briefly,
Okay.
Obviously this is not, this obviously has some more discussion. Please see the author offline.
Be glad
I know there are several people that still have questions, but just see the author offline on this matter. We're going to move on. Thank you.
Thank you.
Representative Gulling.
Thank you, members of the committee. I bring before you the body for consideration HB 881 LC 481076S. It's not currently on the blue sheet. This bill addresses the PAQC, the Prosecuting Attorneys Qualifications Council, that we created last year with SB 92. The measure removes the provision where the Supreme Court must review and adopt the rules and standards of the commission. It also more narrowly defines mental and physical incapacitation. And lastly, it changes the venue for appealing the decision of the hearing panel to the Superior Court Circuit, which the prosecuting attorney serves, rather than the Fulton County Superior Court. I'm happy to answer any questions.
All right. Representative Park.
Thank you, Madam Chair. Is it not true that, in effect, this bill and anyone who votes for it would be taking action to protect Donald Trump from an ongoing criminal investigation based on a grand jury indictment issued by Georgia citizens?
So this bill is not addressing Donald Trump and the Fonnie Willis things that are going on there. If there is a viable complaint in that district or that court circuit, as if there's a viable complaint in any other court circuit. It would address that. If there's not a viable complaint, it would not.
Okay, thank you. No more questions. Thank you.
Thank you.
Representative?
Good morning, Chairwoman Ballinger, members of the Rules Committee. I'm here to present House Bill 905. If the contents of this bill look familiar, it's because this Rules Committee, as well as the House floor, passed the contents of House Bill 905 as part of an omnibus local government bill last year with 7 or 8 topics on it. It got narrowed in the Senate down to 2 or 3 topics, so 905 is a freestanding bill which fine-tunes the zoning procedures law following a 2022 amendment, both of zoning procedures law as well as Chairman Leverett's petition for review law. What this bill does is it returns Georgia zoning procedures law to the long-standing rules from 2022 back to the 1970s or 80s that administrative permits, which are done by city staff people and not elected officials, are not subject to the zoning procedures of notice and hearings. This keeps zoning decisions in the hands of elected officials and zoning board of appeals, but the things that are normally done at the counter in the zoning office or in a conference room, a permit that technical city staff does, are not subject to those requirements, which have slowed things down the last few years. This was brought by some local governments. It was reviewed last year as well as this year as well, and property owners, in addition to local governments, have expressed support for this bill that just fine-tunes that language and returns it to the law that existed for decades prior to that 2022 amendment. Thank you.
Okay, any questions for the author? Chairman Martin.
Question to the gentleman. So am I, in a quick read of this, you're adding conditional use as something that, if it's done administratively, it doesn't have to be advertised, and it can, the conditional uses are big deals in some zoning codes.
That, Chairman Martin, what we've heard is the cities have a variety of conditional use. If a conditional use is defined as a zoning decision, if it's a full-fledged zoning decision as otherwise defined under the zoning procedures law, it would still be subject to notice and a hearing. But some cities have a very technical version of conditional use permits that don't meet the definition of a zoning decision. All zoning decisions by law are required to go through notice and a hearing, but technical administrative permits would not be subject to that process.
I can't afford to pay you by the word there, Mr. Lawyer. But that answers the question. So not all conditional uses are created the same? Is what
That's
you're
right.
saying.
That's right.
Okay, all right, thank you. No more questions. Thank you, Representative.
Thank you.
Members of the committee, do any of you have bills for the consideration? Chairman Martin.
Madam Chair, I have House Bill 985. This is a bill that flowed through the House last year as HB 319. It seeks to abolish the Georgia Higher Educational Assistance Corporation. If the chair will recall, we passed it here with no problems. It passed out of the House with no negative votes. The Senate decided to add a little something to it, and it earned a veto at the governor's desk. So we seek to bring this back quickly and quietly. This would allow the Student Finance Commission to return about $28 million to use for education. I actually have, and turned into the Rules Committee, a resolution from the board over there asking us to do this. And the sooner we could do it would allow us to get it to the Senate and hopefully get the Senate to pass it so that there wouldn't be any day 40 foolishness this next year. So I'd ask the committee's favorable consideration of HB 985 and answer any questions if there are.
Okay, thank you. Seeing none, there are no questions. So we're going to be setting the calendar for Monday. We're also going to be setting the calendar for Tuesday. From Monday, January 29th, from the general calendar, HB 881 under modified structure. Do I hear a move? Second? All those in favor, please signify by saying aye. Aye. Any opposed, like sign. All right, show of hands. Those in favor. Those opposed? Motion carries. So the calendar for Monday, January 29th is House Bill 881. I'd like to recognize the Secretary of the Committee for a motion.
Madam Chairman, I'd like to make a motion. There we go. Madam Chairman, I'd like to make a motion.
Yes, sir.
Pursuant to Rule 133, that the debate be limited to 1 hour on House Bill 881. Time be allocated by the Speaker.
Okay, there is a move to limit debate pursuant to Rule 33.3 to 1 hour, time to be allocated at the discretion of the chair. There's a move. Do I hear a second? There's a move and a second. All those in favor, please signify by saying aye. All those opposed, like sign. The ayes have it. Debate is hereby limited to 1 hour, time to be allocated at the discretion of the chair. For Tuesday, we're going to be setting the calendar for Tuesday, January 30th, under modified structure, House Bill 878. Do I hear a move? I hear a move and a second. All those in favor, please signify by saying aye. Any opposed? House Bill 884. I hear a move and a second. All those in favor, please signify by saying aye. Any opposed, like sign. House Bill 905. All those in favor, please signify by saying, oh, there's a move and a second. All those in favor, please signify by saying aye. Any opposed? House Bill 906. All those in favor, please signify by saying aye. Any opposed? House Bill 976. Is there a move? There's a move and a second. All those in favor of 976 being placed on the calendar, please signify by saying aye. Any opposed? House Bill 985. Is there a move? There's a move and a second for placing House Bill 985 on the calendar under modified structure. All those in favor of that motion, please signify by saying aye. All those opposed? Motion carries. And I recognize the Secretary for a motion.
Madam Speaker, Madam Chairman, I'd like to make a motion to recommit House Bill 907 back to the Committee on Motor Vehicles.
There's a move. Is there a second?
Second.
There's a move and a second. All those in favor of recommitting HB 907 back to the Committee on Motor Vehicles, please signify by saying aye. Any opposed, like sign. It is so ordered. That concludes the business of this committee, and we are hereby adjourned. Oh, I do apologize. Representative Hughley. I understand you have a group to recognize.
Thank you, Madam Chair. I do. I have some constituents here from Columbus, Georgia. They are here as part of Delta Day at the Capitol. And I want the ladies to stand, please. And I want them to know that this is the first day since I've been here that we've ever had a woman to chair the Rules Committee. So you all are here on a great day.
Thank you. I even got the red memo.
So that's Pat Hughley Green, we have Janetta Pendleton, and we have Dorothy Bass. Thank you all for being with us.
Thank you. We are adjourned.